Hello everyone, welcome back to Time Style. This is Advocate Preeti Acharji, and today we will discuss the second part of the first module on law of criminal procedure. Here in this part, I'll be discussing the other four topics, that is hierarchy of courts, power of courts, then police officer, public prosecutor, and further. So to start with, we'll start with the first question, that is on hierarchy of courts.
These are the synopses that you can mention in your answer paper, starting with introduction, then the class of criminal courts, territorial divisions, hierarchy of criminal courts, court of session, then the lower courts coming from court of judicial magistrate, then chief judicial magistrate, additional chief judicial magistrate, subordinate of judicial magistrate, special judicial magistrates, then local jurisdiction of judicial magistrates. Then you can state about executive magistrate, special executive judicial magistrate, local jurisdiction of executive magistrate, then subordinate, and then about the assistant session judge, metropolitan magistrate, high courts, and then the conclusion. Introduction, you can simply mention how BNSS is a foundational structure to criminal courts in India. It provides framework for the administration of justice in criminal matters, state about types of courts in criminal matters, and also their jurisdiction and the role of officers involved. It is a system designed under the law to ensure that justice is delivered efficiently at different level of the judiciary. Now, classes of criminal courts under section 6 of BNSS. So beside our high courts and courts under any law other than this Sanhita, state shall have the following courts. First, court of session, then judicial magistrate of the first class, judicial magistrate of the second class, executive magistrates. Each of these courts handle primary criminal cases at different levels based on the seriousness of the offences. Hence, these are structured to ensure that cases are heard and adjudicated in a way that it is appropriate for the nature and gravity of the crime. Now the territorial division under section 7. Under section 7 clause 1 of BNSS, this lays that every state of India must have a territorial division known as session division, which may consist of one or more districts. Then section 7 subclause 2, which talks about the state government has the right, with consultation with the high courts, to limit the number of such divisions and districts. They can even reorganize and redefine the boundaries of session divisions and districts. Then section 7 subclause 3 talks about that state with further consultation with the high court can create subdivision within districts and may alter the limit of the number of such subdivisions. Then section 7 subclause 4, it talks about that any establishment of session division, district or subdivision should be done under this section of the BNSS. Now in the screen you can see the hierarchy of criminal courts. So in our exam you can remember this diagram where we have shown the hierarchy of criminal courts. The top will be the Supreme Court, then High Courts, then Session Court, which includes Session Judge, Additional Session Judge. There are Assistant Session Judge like Chief Metropolitan Magistrate or Additional Metropolitan Magistrate, then Additional CJM, and then Metropolitan Magistrate, Special MM, then Judicial Magistrate of First Class, Judicial Magistrate of Second Class. So this is the hierarchy of criminal courts under the BNSS. Court of Session under section 8 of BNSS. Court of Session are the highest trial court in a district. The state government is mandated to establish court of session of each session division. Second is that each court of session shall be presided over by a judge which will be appointed by the High Court. Third point is that the High Court will also appoint additional session judge to exercise jurisdiction in the court of session whenever necessary. Fourth point is that the High Court may appoint a session judge of one session division as an additional session judge of another division, and he can sit for disposal of cases at such place where the High Court may direct him. So those of you who have done internship might have observed that in the Shivaji Nagar court, some of the district judges have designation of both district judge and additional session judge. So under this section subclause 4, the High Court by its power can appoint the session judge one session division to also as an additional session judge of another division. Now subclause 5 of section 8 talks about that if the session judge office is vacant, then the High Court may by its power can make a temporary arrangement for the disposal of the urgent applications which may be handled by the additional session judge, or no such judge is available, then the Chief Judicial Magistrate of the session can handle it to avoid any further delay. Now section 8 clause 6 says that the Court of Session ordinarily have its seat at such place where the High Court may by notification specify. However, if in any case the Court of Session is of the opinion that it will tend to, for the convenience of the parties and witnesses, hold its sittings at any other places in the session judge, then with the consent of the prosecution and accused, the judge may sit at the place for the disposal of the case or the examination of any witness or witness therein. Under clause 7 of section 8, the BNSS has also given the authority to the session judge to make orders regarding the distribution of businesses among the additional session judges, ensuring that cases are allocated efficiently based on the expertise and availability of the judges. Now under clause 8, the session judges have the power to dispose of any urgent application in the event of his absence by an additional session judge, and if no additional session judge available, then Chief Judicial Magistrate. Only that the judge or magistrate shall be deemed to have jurisdiction to deal with any such applications. We can talk about the lower courts. The first is Court of Judicial Magistrate under section 9. Clause 1 of the section talks about the establishment of the court. This specifies that the state government with consultation with the High Court can establish the judicial magistrate in each district, categorizing under judicial magistrate of first class and judicial magistrate of second class, and that further the number of the courts and location can be decided by the state government as per the local needs. It can also establish, with consultation of High Court, special courts for specific local areas to handle particular types of cases. This can be of first class or second class depending on the cases. Now when a special court is set up for a specific type of case, no other magistrate court in the area will have the jurisdiction over those cases. Now clause 2, that is appointment of the presiding officers. So under this section, the presiding officer of these courts are appointed by the High Court. Then clause 3, which talks about power delegation of civil court judges. Now High Court has the power to confer the powers of a judicial magistrate of first class and second class on any member of the judicial service of the state who is already functioning as a judge in a civil court, which means that the High Court can assign certain criminal jurisdiction or powers to a judge who typically deals with civil matters if the situation requires it. So the delegation of power helps ensuring that judicial functioning can be carried out efficiently, particularly in cases of shortage of judicial officer or for managing heavy. Now point number 2 is Chief Judicial Magistrate and additional Chief Judicial Magistrate under section 10. So clause 1 talks about the appointment of Chief Judicial Magistrate. So in every district, the High Court is responsible for appointing a judicial magistrate of the first class to be the Chief Judicial Magistrate, and CJM are also considered as the head of the judicial magistracy in the district and is responsible for overseeing the functioning of the judicial magistrate in the district. Now second, the appointment of additional Chief Judicial Magistrate. Again, High Court may also appoint an additional Chief Judicial Magistrate from among the judicial magistrate of the first class. The AGM can also be given all or some of the powers of the CJM depending on the directions by the High Court. Clause 3 then talks about the appointment of sub-divisional judicial magistrate. So the High Court may designate any judicial magistrate of the first class in a sub-division, a smaller administrative unit within the district, to be the sub-divisional magistrate. The CDJM can also be assigned with specific judicial duties in the subdivision, and the High Court may relieve him of certain responsibility if necessary. Then clause 4, which talks about the power of supervision and control of SDJM. Basically, CJM and the subdivisional judicial magistrate has the authority to supervise and control the work of the other judicial magistrate in the subdivision, excluding the additional chief judicial magistrate. Further, the High Court specify the power of supervision and control that the SDJM has over the judicial magistrate in the subdivision through general and special powers. Then the next topic is subordination of judicial magistrate under section 13 of BNSS. So the first clause talks about that every CJM shall be subordinate to the session judge, and that every other judicial magistrate shall subject to the general control of the session judge be subordinate to the chief judicial, which means that the CJM is under the overall jurisdiction and authority of the session court, and the session judge oversees the higher level judicial matters and the CJM reports to them. Further, other judicial magistrate other than the CJM are subordinate to the chief judicial magistrate and work under their general control. However, these magistrates are still subject to general control of the session judge, which means the session judge can intervene if necessary. Then clause 2 talks about the distribution of businesses. So, chief judicial magistrate has the authority to manage the distribution of work among the judicial magistrate who are subordinate, which means the CJM can assign cases and duties to the other judicial magistrate based on their availability, expertise and workload. However, these rules must be consistent with the overreaching. Then there are special judicial magistrate, that is under section 11 of BNSS. So clause 1 talks about the appointment and powers, which says that the High Court can, and upon request of the center and the state government, will appoint a person who hold or has held a post under the government as their special judicial magistrate. Now this power can be conferred upon this special judicial magistrate are the same as those that are granted to the judicial magistrate of the first class or second class, applying to particular cases or particular classes of cases in specific local areas. The qualification of such must have certain qualification and experiences related to the. Now clause 2 of the section talks about the terms of the appointment, that is the SJM are appointed for a fixed term which cannot be exceed 1 year at a time. And further, that the High Court has the authority to issue general or special order determining the terms of their appointment, including the duration, and the term is limited, ensuring that such appointment are reviewed to him. Then section 12, local jurisdiction of judicial magistrate. Now, subject to the control of the High Court, the Chief Judicial Magistrate has the power to make or define the local limit of areas within which a magistrate appointed under section 9 or under section 11 may exercise all its power or any power with which they may respectively be invested under this Sanhita. There is a proviso that says that the Court of Special Judicial Magistrate may hold its sitting at any place within the local area for which it is established. Further, there is an exception of the rule that says that as otherwise provided by such definition, the jurisdiction power of every such magistrate shall extend throughout the district. Then we have clause 3, where the local jurisdiction of a magistrate appointed under section 9 and 11 will extend to an area beyond a district in which he ordinarily holds court, and any reference to this Sanhita to the Court of Session or Chief Judicial Magistrate shall, in relation to such magistrate throughout the area within his local jurisdiction, be constructed unless the context otherwise requires, as a reference to the Court of Session or Chief Judicial Magistrate, as the case may be exercising jurisdiction in relation to the. Now section 13, subordination of judicial magistrate. So under clause 1 of section 13, we'll see that every chief judicial magistrate are considered to be a subordinate to the session judge, and every judicial magistrate are subordinate to chief judicial magistrate but are subjected to general control of the session judge. That means the chief judicial magistrate are under the session judge and the judicial magistrate are under chief judicial magistrate, but however session judge have a general control over the judicial magistrate. Now clause 2, which says The Chief Judicial Magistrate may from time to time make rules, give special orders consistent with this provision of Sanhita, and will distribute the business among the judicial magistrates subordinated to him. Then section 14, that is executive magistrate. So clause 1 of section 14 says that the state government has the power to appoint as many as executive magistrate as it deems fit, and shall also appoint one of them to be as the district magistrate. Now clause 2 says the state government has the power to appoint the executive magistrate to also be an additional district magistrate, and that magistrate shall have such of the power as a district magistrate hold under the Sanhita. Any other law as the time being in force as may be directed by the state government. Now clause 3 says that whenever there is a consequence of the office of a district magistrate become vacant, then any of the officer succeeds temporarily to the executive administration of the district, and that such officer will enjoy the same power and perform all the duties respectively as given to the district magistrate as per this Sanhita. Clause 4 talks about that the state government also has the power that he can make the executive magistrate in charge of a subdivision and may also relieve him of the charge on occasion as required, and then the executive magistrate in charge of the subdivision will also be called as subdivisional magistrate. Clause 5, that the state government shall by any general order or by a special order, subject to any control direction as he may deem fit, will impose and delegate its power under subsection 4 to the district magistrate. That means, as the previous clause that we have seen, that the state government has the right to make the executive magistrate in charge of a subdivision. So this right given to the state government can also be exercised by the district magistrate. As per clause 5, whenever under any special order or any general order the state government imposes on. Now clause 6 talks about that nothing in this section will preclude the state government from conferring under any law from the time being in force on a commissioner of police or any of the power of an executive magistrate. Now section 15, that is special executive magistrate. Now the state government also have the right to appoint as it may deems fit the executive magistrate or any other police officer who is not below the rank of a superintendent of police or equivalent to it to be known as the special executive magistrate. He may act as in the particular areas or for the performance of a particular function and confer on such special executives such of the power as are conferable under the Sanhita on executive magistrate as it may deems fit. That means that the special executive magistrate will be assigned a particular area and will be given some performance for a particular function, and that he may also get the power as equivalent of the executive magistrate. Now section 16 that talks about local jurisdiction of executive magistrate. This section, clause 1, talks about that subject to the control of the state government, the district magistrate has the right to define the local limit of the areas within which an executive magistrate will exercise its power and functions. Now, the clause 2 talks about an exception that as otherwise provided by such definition, the jurisdiction and power of every such magistrate shall extend throughout the. Now section 17, subordinate of executive magistrate. This section, clause 1, talks about that executive magistrate will be subordinate to the district magistrate, and that an executive magistrate exercising its power in a subdivisional shall also be subordinate to the subdivisional magistrate subject to the general control of the district magistrate. Clause 2 says that the district magistrate can make orders time to time, making any special order consistent with this Sanhita as to distribution of allocation of businesses among the executive magistrates subordinated. There were also courts as assistant session judge, then metropolitan magistrate. However, as per the new BNSS, this provision has been repealed. Our higher courts. So, Article 214 of the Constitution of India provides that there must be High Court of every state, and Article 124 of the Constitution states that the provision regarding establishment of the Supreme Court of India. So here we have seen the types of court in the Constitution and how each and every court have its own jurisdiction and their specific appointment are held on, and also the hierarchy of the courts. Now we'll be talking about the provision of power of courts in the BNSS, like how each and every courts are given different power under the Sanhita. This is the synopsis of the question. So the first will start with an introduction, then about the power of courts under BNSS, and then sentencing power of courts. Then we have a diagram where we will be discussing the type of courts, their penalties, maximum fines and other punishments. Then there are sentence of imprisonment in default of fine. An offender falls to pay, or the court may order imprisonment in default. Then there are sentencing for multiple conviction and the restriction on maximum sentences. Further, we'll talk about the mode of conferring judicial power, then power of appointment of officers, and then withdrawal of power, successor judge or magistrate, and then conclusion. So here we'll be discussing the section of BNS. So in the intro you can specifically start that as BNSS as a very significant legislative reform in Indian criminal justice that incorporates both technology, new advancement, new procedures, as well as the acknowledgement of new crimes and new codes. You can also state out that the procedure for investigation, trial, sentencing ensure a fair, effective justice system, which is the outlining feature of BNSS. And then you can state about the key aspect of BNSS, that is the power of court, which defines the jurisdiction and sentencing authority of the different courts in India. And then a sentence you can add where you can talk about that this ensures a structured approach to criminal trials, allowing to fair jurisdiction and adjudication while maintaining a balance between the rights of the accused, victims. So the first will start with the power of courts under the BNSS. We'll start with the jurisdiction of court that falls under section 21 of BNSS. The first will discuss that which court can try offences. Now, any offences under the BNS, that is the IPC, may tried by the higher court than the court of session or any other court by which such offence is shown in the first schedule of the tribal. It also includes a proviso which says that if the offence falls under section 64 of the BNS, then it should be tried as far as possible by court prescribed over by a woman judge, and if an offence is covered under any other law, it shall be tried by the court specialized under the law. Here also you can mention a case of Muhammad Firoz versus State of Madhya Pradesh, where it is said that the court conducting trial appeal is not only obligated to protect rights of the accused but also right of the victims, in order to uphold the equality, justice and liberty policy of Indian Constitution. And the second point is sentencing power of the particular courts. So clause 1 of the section 22 talks about the sentencing power of Chief Judicial Magistrate, that is the maximum imprisonment will exceeding 7 years. It has no specific limit on fine but cannot impose death penalty or life imprisonment. Then clause 2 talks about magistrate of first class that can give maximum punishment not exceeding 3 years, and the fine is up to 50,000 or both. It can also order about community service. Then there is clause 3 that talks about magistrate of second class, and its punishment would not exceed 1 year and the fine will be 10,000 or both. and can also order community service. So the term community service is new to the law, which is defined as any form of punishment where the convict is required to perform work benefiting the society without. Then is section 24 that talks about sentence of imprisonment in default of fine. Now clause 1 says that the court of magistrate can award such term of imprisonment in default of a payment of fine as it is authorized by law, provided that a term of the punishment should not excess the power of magistrate under section 23. It shall also not, where imprisonment has been awarded as part of the substantive sentence, exceed 1/4 of the term of the imprisonment which the magistrate is competent to inflict as punishment for the offence otherwise than as imprisonment in default of payment of the fine. Then clause 2 says that the imprisonment awarded under this section may also be in addition to the substantive sentence of imprisonment for the maximum term awardable by the magistrate under section 23. Then section 25 that talks about sentence in case of conviction of several offences at one trial. This says that where a person is convicted of multiple offences in one trial, then a court can order a separate punishment for each of the offences, and the court shall also decide whether the punishment run concurrently or will consecutively be running. It has also imposed a total imprisonment cannot be exceeding 20 years, and that aggressive punishment cannot be more than twice the maximum punishment for a single offence. Then we have section 26 that is mode of conferring powers. It says that the High Court or the state government are also empowered individuals by name, specific appointment, by designation to an official position, or make any such order that take immediate effect upon communication. Then we have section 27 that talks about power of appointed officer. The first talks about that if a government officer with judicial power is transferred or promoted within the same jurisdiction, they can retain their existing judicial power unless otherwise directed by the High Court or state government. Then there is withdrawal of power under section 28 of BNSS, which says that the High Court and state government can withdraw judicial power conferred under BNSS, and a chief judicial magistrate or district magistrate can also revoke power granted by them. Then we have section 29 that talks about successor judge and magistrate, which says that if a judge or magistrate is replaced, then the successor in office assume their judicial duties, and if there is an uncertainty that about who will be the successor is, then the session judge which will issue an official order determining the rightful successor. So these are all about the power of each courts as defined under the BNSS. So now we have come to the conclusion part where you can just make a statement how structured based on the hierarchy of courts this power of courts are being defined, which says about different level of sentencing authority. Then you can also state about the framework that it ensures, that is fair trial, proper jurisdiction, sentencing limit for different level of courts, judicial continuity, administrative clarity in each case of transfer. Now question number 5, that is power of police officer and aid to magistrate and the police under section 30 to 34 of BNSS. Let's quickly see the synopsis. So it starts with an introduction, then you can go to the power of superior officers of police. Then there will be public duty to assist magistrate, and then person executing a warrant. Then applicable offences for the duty of officers and village official to report. So in the intro you can state that how BNSS deals with the power of superior officers of police and the aid provided to the magistrate and the police under this BNSS. We can also write about what it outlines, like the legal framework that governs the responsibility and authority of senior police officials, as well as the obligation of citizens and other officials in assisting the police and magistrates in law enforcement and crime prevention. So this Question: ensure the effective functioning of law enforcement agencies by empowering higher ranking police officers and making it mandatory for citizens and village officials to assist in upholding the law and order. So after the intro, you can also state about police officer. So in the previous video, as I have talked about police officer in general, so you can use the same definition over here, describing what does the police do, their hierarchies and all. You can copy paste the same, can learn out the same and can add here as a. Then we'll proceed with power of superior officers of police. That is section 30. Now, so the police officer superior in rank to an officer in charge of a police station can exercise the same power throughout the local area to which they are appointed and may exercised by such officer within the limit of his station. That is, the superior police officer will have the same authority as the power conferred to the office in charge of police station within their jurisdiction. Now the key points over here are that any police officer holding a rank superior to the office in charge of a police station can exercise all the power vested in the latter within that police station limit, and that this provision is a smooth chain of command and operational efficiency in law enforcement, which allows senior officer to intervene, direct and oversee police activities to maintain law and order effectively. Now we have section 31, which talks about public duty to assist magistrate and police. Under section 31, it says that every person are bound to assist the magistrate and police officer reasonably demanding his aid. Firstly, in taking and preventing the escape of any other person whom such magistrate or police officer has already authorized to arrest. Second is in the prevention or suppression of breach of the peace. And thirdly, in the prevention of any injury that has been attempted to be committed to any public property. Now we can go to section 32, which talks about aid to a person other than police officer executing warrant. Now when a warrant is directed to a person other than police officer and any other person may aid in the execution of such warrant, now if the person to whom the warrant is directed to be near at hand and acting in the execution of the warrant, which means that the section obligate individual to report certain offences to the nearest magistrate or police station, and it applies specifically to a person aware of the commission or intention to commit. Now there is applicable offence under BNS. Now this requirement to inform authorities applies if the offence falls under the following section. That is section 103 to 105, that is offence related to abduction, kidnapping, wrongful confinement. Then there is section 111 to 113, which talks about offences involving conspiracy, sedition and unlawful assemblies. Then there is section 140 to 144, which talks about offences against the state and public order. Then there is 147 to 154 and section 158, which talks about offence involving riot and unlawful assembly. Then section 178 to 182, which talks about offences related to the obstruction of justice and false statements. Then we'll come to section 189 to 191, offence related to the threats to public servant and giving false evidences. Then there is section 274 to 280, offence related to adulteration of food and drugs. Section 307, attempt to murder. Then section 309 to 312, offence related to suicide and causing miscarriage. Then subsection of 5 of 316, offence related to death of an unborn child. Section 326 and 328, offence related to grievous hurt, causing hurt by dangerous means. Then there is section 331 and 332, offence related to causing grievous hurt to deter public servant from duty. Now the key provision over here that the failure to inform authorities without a reasonable excuse make the individual liable. Now this burden of proving a reasonable excuse rests on the person who failed to report, and the law applies to offences committed both within and outside India if they would constitute an offence under Indian law. Now here under this section we and that this kind of offences must be reported by an individual to the magistrate and police office, and it will subject it to the section 32. Now duty of officers and village official to report, section 34. Now this section mandates a village officer and
Resident reports specific incident to the nation. Firstly, it talks about mandatory reporting requirement, that the presence of known receiver or seller of stolen good in near the village. Then there is movement of suspected criminals, plan or execution of serious criminal offences, suspicious death, disappear or discover of bodies within the village, criminal offences occurring outside India but near the village. So under this section there are definition given to village, which includes village land and surrounding areas. Then the proclaimed offender is defined as person declared a fugitive by any court or authority in India for serious crimes, and village officials is stated as panchayat member, village headman and appointed administrative personnel. And reporting procedure means that this information must be provided to the nearest magistrate or police station, whichever is close, and which will ensure timely intervention by law enforcement authorities and prevent crimes. And lastly, the conclusion, where you can conclude simply with that how this structure and hierarchical legal framework helps the law enforcement authorities, especially the superior police officer, who are granted the authority to direct and supervise their subordinates. Then police cooperation mandates to law and enforcement agency in criminal prevention and maintenance of public order. So this question, it is very short. It will the marks of 10 or as a short note, which you can define simply by stating all these sections given under that. And coming to the if you want to remember all the applicable laws, then you can simply remember the sections and all, and if not possible to remember the sections, then only the offense name will be enough. Like abduction is there, then there is all sort of criminal offenses you can write out, like attempt to murder, attempt to suicide, provocation of suicide, and then miscarriage, then death of unborn child. Also this sort of offenses can be. Now lastly, we have the provision related to public prosecutor and their function. So that the synopsis start as introduction, definition of public prosecutor under BNSS. Then there is section 18, which talks about the definition, appointment of in high court level, appointment at district level, then qualification of select criteria, special public prosecutors. Then section 19, which talks about assistant public prosecutor. And then section 20 that talks about director of prosecution. Then challenges faced by the public prosecutor. And here in the intro you can start as that chapter 2 of BNSS placed on comprehensive provision regarding the appointment, role and function of public prosecutor within the criminal justice system. So public prosecutor can be said as a representative of the state and are entrusted with the responsibility of prosecuting criminal cases on behalf of the government. Their primary obligation is to ensure justice is served, simultaneously upholding the rights of the accused and maintaining fairness in the legal proceeding. It also plays a role in critical ensuring that criminal trials are conducted effectively and efficiently. They also act as a bridge between the judiciary and the investigating agency, ensuring that evidences are presented coherently. So now there is section 2 clause V of the BNSS, which talks about public prosecutor. Here the definition is given as that any person appointed under section 18 and includes any person acting under the direction of public prosecutor will be considered in the term under BNSS. Now this section directs us to section 18 of BNSS, which talks about the public prosecutor, where the section provides a detailed framework for the appointment and the responsibility of public prosecutor at various levels of the judicial system. So first is the appointment. So the center and the state government is responsible for appointing a public prosecutor to the High Court. Now special provision exists for National Capital Territory of Delhi regarding such appointment. The central government also retains the authority to appoint. Now the central government also retains the authority to appoint public prosecutor for specific district or local areas as necessary.
Now the appointment at district level are done by the state government, who holds the authority to appoint a public prosecutor. This provision made for the appointment of public prosecutor also operate across the multiple district if required, and that the preparation of panel of eligible candidates is carried out in consultation with the appropriate legal authorities to ensure the selection of a competent professionals. Now the qualification and selection criteria. Now clause 3, which talks about that the state government is responsible to appoint a public prosecutor in every district and may also appoint one or more additional public prosecutor for the district. And then there is a proviso which says that the appointed one may also be appointed to be the public prosecutor or additional public prosecutor as the case may be for another district as well. Now clause 4 says that the district magistrate shall, with consultation with the session judge, prepare a panel of names of persons who are in his opinion to be fit to appoint a public prosecutor or additional public prosecutor for the district. Now the fifth one is that no person shall be appointed by the state government as a public prosecutor or additional public prosecutor for the district until and unless their names appear in the panel of names prepared by the district magistrate under subsection 4. Sixth, that notwithstanding anything in the subsection 5, that where in a state there are a regular cadre of prosecuting officer, the state government shall appoint a public prosecutor or an additional public prosecutor only from among the person consulting such cadre, provided that in the opinion of the state government there is no suitable available in such cadre for such appointment, then the government may appoint a person as public prosecutor or additional public prosecutor as the case may be from the panel and the names prepared by the district magistrate under subsection 4. Now here we have some of the meaning, like a regular cadre of prosecuting officer, which means that the cadre of prosecuting officer which will include therein the post of public prosecutor by whatever name called, and which provides the promotion of assistant public prosecutor by wherever name called to the post. Now the prosecuting officer means a person by whatever name called appointed to the platform to perform the function of public prosecutor, special public prosecutor, additional or assistant under the Sanhita, and that a person shall be eligible to be appointed as a public prosecutor or additional public prosecutor under subsection 1 or subsection 2 or subsection 3 or subsection 6 only if he has been in practice as an advocate for not less than 7 years. Now the 8th point is that the central government or the state government may appoint for the purpose of any case or class of cases a person who has been to practice as an advocate for not less than 10 years as a special public prosecutor, provided that the court must permit the victim to engage an advocate of his choice to assist the prosecution under this subsection. Now point number 9, that is clause 9, which says that for the purpose of subsection 7 and subsection 8, the period during which a person who has been practiced as an advocate or has rendered wherever before or after the commencement of the Sanhita services as a public prosecutor and additional public prosecutor or assistant or other prosecuting officer by whatever name called shall be deemed to be the period during which such person has been in practice as an advocate. Now we'll talk about assistant public prosecutor, where it states the state government here has a right to appoint in every district one or more assistant public prosecutor for conducting prosecution in the court of magistrate. Then the central government may appoint one or more assistant public prosecutor for the purpose of conducting any cases or classes of cases in the court of magistrate. Then, without prejudice to provided content in the subsection 1 and 2, it says that no assistant public prosecutor will be available for the purpose of any particular case. Then the district magistrate may appoint any other person to be as the assistant public prosecutor in charge of that case after giving notice of 14 days from the state government to the state government, provided that no police officer shall be eligible to be appointed as an assistant public prosecutor, and that if he has to take any part in the investigation into the offences with respect to which the accused is being prosecuted, or is below the rank of inspector. Now section 20 says Directorate of Prosecution. The state government established that a director of prosecution in the state consists of a director of prosecution and as many as deputy directors as it may think fit. A district director of prosecution in every district consists of many deputy director, assistant director of prosecution as it deems fit. Second is a person shall be eligible to be appointed as a director of prosecution or deputy director of prosecution if he has been practicing as an advocate for not less than 15 years or have been a judge of session. Now the second is that an assistant director of prosecution can be appointed if he has been in practice as an advocate for not less than 7 years or have been a magistrate of the first class. Then the position of director of prosecution shall be headed by the director of prosecution who shall function under the administration control of the home department in the state, and that every deputy director of prosecution or assistant director of prosecution shall be subordinate to the director of prosecution, and every assistant will be subordinate to the deputy director. Now clause 5 says that every public prosecutor, additional public prosecutor or a special public prosecutor shall be appointed by the state under subsection 1 and 8 of section 18 to conduct cases in the High Court and shall be subordinate to the director of prosecution. Now 6 is that every public prosecutor, additional or special, appointed by the state under subsection 3 and 8 of section 18 can conduct cases in district courts, and every assistant appointed under subsection 1 of section 19 shall be subordinate to the deputy director of prosecution or the assistant director of prosecution. Now point number 7 talks about the powers and function of the director of function. Now clause 7 talks about the powers and clause 7 talks about the powers and function of director of prosecution, that it shall be to monitor cases in such way that the offence which are punishable for 10 years or more or with the life imprisonment or with death, or to expedite the proceeding and to give opinion on filing of appeals. Clause 8 talks about the powers and function of deputy director of prosecution and shall be to examine, scrutinize police report and monitor the cases in which offences are punishable for 7 years or more but less than 10 years for ensuring their expedite disposal. Now clause 9 says that the function of the assistant director shall be to monitor cases in which offences are punishable for not less than 7 years. So the function of the assistant director of prosecution shall be to monitor cases in which offences are punishable for less than 7 years. Now point number 10 says that nothing withstanding anything contained in the subsection 7, 8 and 9, the director, deputy director and assistant director of prosecution shall have the power to deal with and be responsible for all the proceeding under the Sanhita. Then clause 11 says that the other powers and function of the director of prosecution, deputy and assistant, and the areas for which each of the deputy or assistant have been appointed shall be such as the state government may be notified specifically. Then the provision of this section shall not apply to the advocate general for the state which performing the functions of a public prosecutor. Now the challenges faced by the public prosecutor. The first challenge is having a heavy workload. The public prosecutor frequently handle a vast number of cases, and hence the excessive caseload can impact the quality of their prosecution, leading to inefficiency in the judicial process. Then there is lack of resources. Many prosecution offices suffer from insufficient funding, which limit their ability to conduct thorough investigation in the case and prepare their cases effectively. Now, pressure from various stakeholders. Public prosecutor may experience undue pressure from political entities, victims and defense attorneys. Navigating the external influence while ensuring impartiality and justice remain a significant challenge. The conclusion, where you can simply mention how the public prosecutor has played a fundamental role in maintaining the law and order in the state and how it ensures the offenders are prosecuted in accordance with law procedure. Then the responsibility including presenting evidences, guiding investigation and upholding the principle of justice without bias. So finally you can wind up stating how this enhances the effectiveness of public prosecution and how the challenges that they are facing, and also assessing the challenges will surely make them able to make reforms and institutional supports that will also strengthen their credibility and efficiency of the prosecution process, leading to a more just and equitable society.
So this is all that we have to discuss in the first module, starting from foundation of criminal procedure, then BNSS, its objective, scope, and further on hierarchy of court, types of courts, and then police officer, public prosecutors, and their function. So in my next video, I'll be discussing with you the second module. Till then, I'll request you to please like, share, and subscribe Timeless Trial so that you don't miss any updates from our channel. And also let us know in the comment section that what else topic that you need us to make a notes on to help you through your exams. Thank you.